Welcome, everyone. Welcome, everyone, as we are waiting for some of our other members to join. We just want to say a warm welcome to you all to the 2024 Young AIPPI Members Virtual Summit, and today featuring the European Satellite Session. So I'm Samantha Young. I'm the Vice Chair of our Young AIPPI Members Advisory Committee. And we're so glad to have you all today with us in this satellite session. Before we officially start, I'd like to share a couple of housekeeping items with you all for your attention. So this event will be recorded and made available on the AIPPI YouTube channel. So you can revisit back into the YouTube channel. During the presentations, we ask that you all mute yourself so we don't disturb the speakers. But questions to the speakers can be submitted and raised in the chat box or during the Q&A sessions. So remember to type whatever questions you have in mind in the chat box. For any technical problems you experience, do feel free to send a message via the chat box directly to AIPPI Events. And our AIPPI Events team will help you with that. If you're interested in getting any of the slides used today, please send a request to events@aippi.org, which will then be made available to you upon request. So I hope you all will enjoy this session as much as I will, and I look forward to the panel session coming. Before we start, I'd like now to pass the floor to our chairperson of our Young Members Committee to say a few words. Debbie, over to you, please.
Thank you so much, Samantha. And again, on behalf of the committee, just a very warm welcome to everyone. And just really thankful and thank you so much for all being here today. As Samantha has mentioned, today is day 2 and we're on Satellite Sessions Day. So as I continue to talk, if you had joined us yesterday on the global session, I want you to type in the chat, I was here at the global session, just so we know how many people are actually joining us from yesterday's session. So just really excited that you can join us today and you're in for a great program this afternoon, or well, this afternoon my time, but it's morning time in Europe. And again, it's just a forum that is by our young members and for our young members. So just want to say a huge thank you to our speakers for all their time and contributions towards the panel this morning and for allowing us to learn from you. A special thank you also to the support from the Bureau General Secretary and the events team, all such amazing people who've been so supportive of the young AIPPI members, and also the committee for all their work in making this summit be able to happen. Last but not least, of course, the attendees, all of you that are here today attending this session. As you know, we're trying out a new format today, and so today is a satellite day. Yesterday, we featured 3 amazing panels in the soft skills session, and today we're looking at 2 panels for this morning as well. So I really am very honored to also invite Simone van der Winkel, who is the Assistant Secretary General of AIPPI, to share her opening remarks with us this morning. So Simone, over to you.
Thank you, Debbie, and thank you all of you for being here and welcome. So I'm going to briefly introduce myself. So I'm Simone van der Winkel, I'm from Belgium, and I'm member of the AIPPI Bureau. I'm part of the team of Nazli Korkut, who introduced the general event yesterday. She's the Secretary General of AIPPI, and I am indeed Assistant Secretary General. I have joined the Bureau only very recently in October 2023. And I am very lucky that thanks to being part of the SGT team, I am involved with the activities of the AIPPI Young Members Committee, because I myself had just aged out of the group of the young members when it was created. So thanks to this, I am able to participate through the sidelines. And I have to say that the work that the Young Committee is doing is just absolutely fantastic. And I want to thank all the members of the committee for everything they do and for preparing and organizing this summit. And I think the AIPPI Young Members Committee has just been increased and fostered so well these recent years, and it's just a pleasure to see and to be a part of. So in the name of the Bureau, I want to thank you all. I want to thank the speakers for coming today, and also all our attendees, the AIPPI members, but also the plus ones who have joined. It's also very exciting that we are able to work with this new format this year, with a global session yesterday, and then the satellite sessions focused on the regions today, which makes it easy for some people from different geographic locations to participate within their time zone, but also when the topics are a bit more region focused. So I think it's a fantastic format to be trying out this year. And so today we have the European session with trademark-ish topic and an update on the UPC, which I think are two topics that are very relevant for all young practitioners, and everyone can learn a great deal today. So I really hope that you will enjoy this session. I just want to give a last remark. As Nazli also said yesterday, if you have not yet registered for the World Congress in Hangzhou in October, the early bird is available until the 9th of July. And I would very strongly encourage anyone who is hesitating to come and attend. I personally started attending the World Congresses when I was still a young practitioner, around when I was 30. And I learned so much. It was such an amazing experience. I made so many friends that's all over the planet. It has really literally changed my life. So I would encourage anyone who is able and hesitating maybe to come join us in Hangzhou in October. So thank you very much. And I pass it back to Samantha or to Debbie.
It's to me, Simone. Thank you so much.
And I wish you a wonderful session. Thank you.
Thanks, Simone, and thank you so much for sharing your background and your experience at AIPPI. I cannot help but second that, because that was also my experience attending the congresses. So yes, fully agreed, and thank you so much for your opening remarks. So without taking up any further time, we now jump into our sessions for today. And for today, hosting the sessions and moderating the sessions will be a member of our young committee as well, that you can get to know through the course of today, and who is none other than Nicholas Gajek. So Nicholas, I will hand the session across to you.
Thank you so much, Debbie. And thank you, of course, Samantha and Simone, for the lovely introduction. We've already heard that we're gonna have two panels following now. And the first one is centered on soft IP issues, in particular bad faith patterns, trademarks, user interface, and beyond. If you have any questions during the presentations afterwards, please feel free to put them in the chat and we will moderate them right after the speakers are through with their presentations. Which brings me to the next point, our wonderful speakers for session one, who are Rebecca Hendrich and Sinem Saracoglu. So Rebecca is a German lawyer specialized in IP law, and the practice focuses on trademarks and designs. And Rebecca has extensive experience in trademark and name disputes before German and European courts, trademark offices and courts as well. And she's a partner at Hendrich Patent, a German IP boutique. Second speaker in our first panel will be Sinem Saracoglu, and Sinem is a legal counsel and Turkish qualified lawyer in corporate, commercial, intellectual property matters, and she's also a registered trademark and patent attorney before the Turkish Patent and Trademark Office. Sinem is one of the partners in Capital Legal Partnership, and she focuses in corporate law and IP law. Finally, as a third speaker for the first panel will be Monika Gaczkowska. Monika is a lawyer at Bird & Bird and expert at the Advertising Council. Monika gained her professional experience working in international law firms and specializes in intellectual property law, including trademarks, e-commerce, and digital transformation issues. Monika supports clients with legal aspects of advertising, subscription, dark patterns, influencers, and traditional IP issues. And in terms of structure of the presentation, I think Rebecca will go first with a focus especially on non-registered name rights and designations. Sinem will be second with bad faith trademark applications. And finally, we will hear from Monica on dark patterns. And without further ado, I'll hand it over to Rebecca, and we're very much looking forward to her presentation.
Well, thank you very much, Nick, for your kind words. I will need a second to start the presentation, which you should be able to see now. Nick, could you give me a short feedback? You see the right screen?
I don't see your presentation yet. Oh, there it is. All right.
Okay, perfect. Thank you very much. Seems to be a bit slow today, but nonetheless, very much a warm thank you for your introduction. And let's start right away. I'll try to keep it as short as we said it would be. And my presentation is about non-registered name rights and non-registered designations, an area and a topic that I feel sometimes somehow handled on the sidelines and maybe overlooked sometimes, but it is very important to consider during litigation and even before. Because when we usually think about trademarks, we think mostly about registered trademarks. But registered trademarks are only a part or a subsection of all the designations and name rights we have to our in our toolbox to use when our clients are trying to protect their business. So maybe the most common or the most well-known trademark rights are the three on the left, which would be registered trademarks or trademark rights that you gain by use or public recognition. And then, of course, you can up that one more when you have a well-known or famous trademark. But there are also name rights, which could be civil name rights or company name rights. And then you have something special, which is a commercial designation, which is somewhat of a merger between a name right and it can have trademark-like qualities, but it is not exactly the same. So we will have a look into that very briefly too. And then the last one, the last panel is copyrights or title of works, which is somewhat exotic, but can happen too. And what we will do is I will just have a very short case for every type of designation right to illustrate it. And then afterwards, you will have a short takeaway what to look for when you use or when you have to fall back on non-registered rights during litigation. What is important to consider is that all these different rights have a different scope and direction of protection. So a trademark is used to show the origin of a product and link the product to a company, to a specific company. So you can think about it as the name of a product, just to help yourself distinguishing the different sorts of rights we're talking about. And also a non-registered trademark, so a famous one, would still link the product to the company. Names and company names are a little bit different because they're not linking a product or a service to a company, but they are set up to distinguish a certain person, which can be a natural person or a legal person, or objects or companies from one another. So they are not linking the products, but they are just saying what specific person or object you're talking about. You can see here as my cute little pictures that also not only companies, but even objects such as houses can be, or buildings in general, can have a name right to themselves. There are also voices in the literature that say it should be possible that pets and animals can have name rights, which then would have to be claimed by their owners. And I immediately had to think about all the famous Instagram and TikTok pets. So it is really, you can think about cases coming in the future where this might be a problem. Who can claim the merchandising rights from a certain pet? Then I brought a case as an example for a name right for a legal person, because I think a name of a natural person, you and me, is somewhat obvious. Usually it is defined within civil law, but a legal person can be more difficult. I brought a case which is quite old, but it would be decided the same today. And it is about the German Red Cross, which you can see the emblem here is on the left side, a red cross on white background, and on the right side, the formal word designation. And what was decided in this case is that not only the words, so Deutsches Rotes Kreuz, which would be German Red Cross, but also the figurative part, so the graphic, the red cross on the white ground, there is also protected as a name right or analog to a name right. And in this case, you can already draw a distinction about name rights that can be distinctive by themselves, or name rights that you would have public recognition to claim as a right because they're not distinctive on their own. And in this case, it was found that the Red Cross is famous and it is even protected by international treaties. So the use of a, let's say, brown cross would infringe the name right to this emblem, to this graphic. This was important in this case because the specific association that was claiming the infringement did not rely on a trademark right, because it was a subsection of the Red Cross. Okay. Another example for a name right, which would not have to be for a registered legal association, but just can be claimed by an organizational unit, would be the young member, ARPPI member logo, which I really like because I think it's very dynamic. And I'm not aware of any court decisions yet, but you would have very good chances to claim a name right to the emblem and the word itself, where the word itself might be descriptive, might be, but the logo in total with the flowering tree, that would be certainly be protected as a name right. And all you have to do to gain this name right is to use it, which we do extensively. When in this case, we see a combination of name rights and special designations. Special designations are, as I said, are a bit of a mixture between trademarks and name rights, because what they do is they are signs that are distinguishing a certain business or a certain organizational unit from others, but they are also linked to specific products and services, because the commercial designations are part or are only protected within the specific industry. What we see here is a case where the District Court of Hamburg decided that the building you see on the left, which is a famous opera house in Hamburg, which is also, it was built and now is run by the city of Hamburg itself, could not only claim a name right for the building itself, which is called Elbphilharmonie, but it could also claim that commercial designation right. So the organizational unit of the part of the city of Hamburg that runs the opera house also can claim this right to the name Elbphilharmonie. And out of this, and this was a very, like a typical case, because they do have trademarks, but the trademarks registered were filed later than the trademark by a third party, which you see on the right, than the, well, than the good faith trademark applications by the actual owner. So what you see on the right is a depiction of the building. I think you can recognize it quite well. And below you can see the letters Elbphi, which are very similar, or which are the first letters of the actual building's name. And the court decided that this trademark application would infringe the name right, the right to the name of the building and the right to the commercial designation. And in the end, it was, the court decided that this trademark application would have to be cancelled and cannot be used, but specifically not because of the trademark, but because of the prior right to the commercial designation. Commercial designations can be a lot of things, not only the name of the building, for example, or the name of the organizational unit that is organizing all the concerts, but it can also be appearances of employees, shop fittings, employee clothing, might be even price tags in corporate colors. But with all these, let's call it abstract things, you have to remember that they are usually not distinctive for the products you want to advertise with them. So just because you have a price tag in corporate colors, the public is not used to receive information about the origin of this price tag just by seeing the colors. So you would usually have to prove public recognition. And in this case here, before the High District Court of Nuremberg, the price tag in corporate colors was not protected as a commercial designation, but the court said it could have been if they proved the public recognition. This is one of my childhood heroes, so I wanted to include it because it shows that when you research for trademarks in advance of a trademark application, you really have to be aware of these non-registered rights, because in this case, the figure of Obelix, which is a comic figure, was found to be protected as a work title, a title of the copyright protected work. And the owner claimed or put forward an infringement claim against this German trademark, or I think it's an Austrian company, Möbelix, which sounds somewhat similar. And it is a German play of words with the word for furniture. And this is what they did. They're dealing with furniture. And the High District Court of Hamburg decided that this work title, so the name of the figure, could be held against this trademark, but so at the first step, it could be a prior right to be held against this trademark. But then in a second step, they found no similarity, especially considering the different areas of industry. But you have to be careful, and you would have to consider a risk when assessing the trademark or the registrability of this trademark. And what would be interesting to notice is that the owners of the Obelix figure, they also had trademark trademark registrations, but they could not prove the use of their trademark. So again, a case where the non-registered rights were very useful during litigation. So what you want to take away, or what you can see by my presentation, is all these non-registered rights, name rights, commercial designations, special designations, names of buildings, they can be valid prior rights, and they can be, on the one side, dangerous for your own trademark, but on the other side, they can be your ground for an opposition or for nullity proceedings, and you can use them as a valid ground for infringement actions. So you do have a powerful asset, because what the consequence of all these rights is, they give you nearly the same rights as a registered trademark would do. So they entitle you to injunctive relief. You can send the same cease and desist letter based on your non-registered right than you could with a registered trademark. You have claims for information, and you have claims for damages. But of course, there's a downside, because you have no register to rely on. You have to prove everything during litigation, and everything really means everything. So you have to prove what kind of right are you claiming. You could claim all of them, but usually this would be not beneficial for cost reasons. So you have to make sure, is it the name of a product you're claiming, or is it the name of a company? Is it the name of a building, of an object? And then you have to prove, when was it first used? So what priority can you claim? In what form was it used? Was it used as a word, or was it only used as a graphic? By whom was it used, and in whose favor? Which can be quite difficult to prove if more than one person or unit is using the same trademark. Who's the same designation? Who's the owner? Who would be recognized by the public as the owner of this right? So you have to put a lot of effort into proving all the different points, and you really have to go the extra mile there. And you have to remember that there's another downside to these non-registered rights, because usually you can't license them, as they are very strongly connected to the object that they are designating, the company, the person. You usually can't license just the right, but you would have to sell the whole part of the company if you want to transfer these rights.
Okay, Rebecca, maybe we can we shorten that a bit? Yes.
Yeah, this would be my last my last point. And so these are the takeaways. The non-registered designations are very valid and very important to remember at all parts of a brand marketing timeline. And you'll have to make sure to compile suitable and comprehensive evidence. So you have to go the extra mile while using them during litigation. And that would be all. Thank you, Nick.
Okay, thank you, Rebecca. And I think we already started a bit later because of the introduction. So I think we should hand right over to Sinem for her a wonderful presentation, and again, happy to take the questions, any questions at the end.
Yeah, hello. I will share my screen now. Can you see all my screen? Yeah, okay. Dear colleagues and participants, it's a great honor to address the distinguished audience at the Young AI PPI Member Summit. Today I will discuss a critical topic in intellectual property law, repeated trademark application and bad faith. Trademark law protects the distinctive marks different cheating goods and servicing of one entity from another. However, this protection can be undermined by bad faith practices, particularly through repeated trademark applications, distorting the market, impeding fair competition, and creating significant challenges for businesses and legal professionals. In this presentation, we will explore the concept of bad faith in the context of repeated trademark applications. We will delve into the legal frameworks and standards that govern this issue, examining case studies. Trademarks are essential tools for businesses. Trademarks are essential tools for businesses to protect their brand identity. Bad faith trademark registration means the misuse of the registration system for unintended purposes. Repeated trademark application may involve filing the same or similar trademarks multiple times to extend protection or prevent competitors from using similar marks. Understanding whether repeated applications can be considered bad faith is crucial for both legal protection and business strategy. By recognizing the signs of bad faith, businesses can protect their trademarks more effectively and avoid costly legal battles. Preventing bad faith registrations maintains a fair market environment, fostering trust among consumers and businesses. Yes, to fully grasp the concept of bad faith in trademark application, we must explore the legal frameworks governing this issue. Bad faith registration was first regulated in the First Consul Directive 89/104 EEC of December 1988, but the directive did not provide a definition. This lack of definition has made it necessary for court decision and doctoral views to determine the concept scope. A similar situation exists in Turkish intellectual property law. The concept of bad faith trademark applications or registration is not clearly defined. Similarly, the term bad faith is not explicitly defined in European Union legislation related to trademark. However, in one of its decision, the EU EPO defines bad faith as a form of dishonest intention. Yes, yeah, according to Article 59 of the new EU trademark regulation, bad faith trademark applications are grounds for refusal and invalidity. In Turkish legislation, regulates bad faith applications as relative grounds for refusal, requiring third-party opposition for rejection. Therefore, in Turkey, bad faith will not be examined ex officio, but will be considered if an opposition is filed. Yeah, what is bad faith? Having outlined the legal frameworks, let's delve into what constitutes bad faith in trademark application. Bad faith occurs when an applicant exploits the registration system for unintended purposes, such as preventing others from using a similar mark or demanding payment for transferring the mark. Indicators of bad faith include a lack of genuine intention to use, prior knowledge of existing trademarks, a pattern of conduct, opposition and litigation history, and the geographic scope and expansion of trademark application. Yes, to illustrate this concept, let's consider the case of Schokoladefabriken Lindt Sprüngli AG Hauswirt GmbH. This case highlights issues surrounding bad faith in trademark registration. Lindt's registrations of chocolate bunny with a red ribbon led to a lawsuit against Hauswirt, which had been selling similar bunnies since 1962. CJEU outlined criteria to assess bad faith, such as the applicant's knowledge of existing trademarks and their intention to provide others from using similar marks. The Austrian Supreme Court ultimately declared Lindt's trademark registration invalid due to bad faith. Yeah. Building on the Lindt case, here are some concrete examples of bad faith indicators. Registering a famous trademark, intending to sell it back to the original owner, a commercial representative registering a trademark without the owner's permission, and repeated files to avoid prolonged use and extend the grace period. These examples underscore the various ways bad faith can manifest in trademark application. Now, let's focus on the practice of related trademark applications. This involves filing for the same or similar trademarks multiple times to maintain protection and prevent competitors from using similar marks. While this can be a strategic tool, it can also distort mark dynamics and impede fair competition. On the right side of the presentation, you can see the image. It is a trademark registered with the Turkish Patent and Trademark Office. It is observed that the trademark has been registered in all classes at 5-year intervals. The protection period of the registered trademark is 10 years from the application date, and this period is renewed in 10-year increments. However, if proof of use is requested, a trademark that has not been seriously used in Turkey by the trademark owner for the goods or services, for which is registered with 5 years from the registered date, or if use has been interrupted for 5 consecutive years without a justified reason, the trademark may be cancelled. In practice, we sometimes see repeated application made in bad faith to avoid the burden of proving use. When trademark owners file a new application for the same goods and services for an already registered trademark, these marks are referred to as a repeated trademarks. There are several main reasons why companies engage in repeating files. One reason is to ensure that trademarks are always registered and active, thus making them always enforceable and easier to defend against infringement and unauthorized use. This is particularly important for well-known brands, as maintaining a consistent and exclusive brand identity is crucial for market positioning and consumer trust. By continuously protecting the trademark, companies can strengthen their brand and prevent infringements. And another reason for repeating filings is to prevent competitors from using similar trademarks. By creating a ticket of registrations, companies can make it difficult for competitors to find and use a similar trademark. This strategy helps companies maintain a unique market presence and in competitive markets, and reduce the risk of dilating the brand identity. Consequently, companies can protect their market share and prevent consumer confusion. Additionally, some jurisdiction may have legal loopholes that allow repeating filings to be used as strategy advantage. Companies might use these legal nuances to extend their trademark protection, deal illegal challenges, or navigate around use requirements. By exploiting these legal loopholes, companies can protect their trademark for longer periods and gain an advantage over competitors. Yeah, there is another case study.
Can we maybe come? Sorry, Sinem. Can we maybe come to the conclusion shortly?
Okay.
Just in order not to cut into Monica's time too much.
Okay, sorry about that. A permanent example is the Hasbro case, which underscores the issue with repeated trademark application and bad faith. In this case, EU-IPO evaluated Hasbro's attempts to register the monopoly trademark for the same goods and services, despite having existence registration from 1998, 2009, and Hasbro's re-registration of the monopoly trademarks was deemed an attempt to avoid proving genuine use, leading to the invalidation of their 2011 registration. This case emphasized the importance of demonstrating genuine use and the legal consequences of strategic filings to extend trademark protection without actual use. Yes, but allegation of bad, however, is not correct to assume that every repeated trademark application is made in bad faith. The Pelican decision is also a good example of this. The Pelican decision further highlights the importance of carefully evaluating allegations of bad faith. The European General Court ruled the Pelican Vertriebsgesellschaft was not made in bad faith. The case involved a trademark registered in 1996 with a subsequent application filed in 2003 and registered in 2008. The court concluded that there was no concrete evidence showing Pelican acted in bad faith, and that the 2003 applications list of services was more specific and narrower than the 1996 application. Yeah. In conclusion, understanding bad faith in trademark application is essential for lawyers and businesses. While repeated trademark application can be a strategic tool, they must be carefully evaluated to avoid bad faith practices that distort market dynamics and create legal challenges. Thank you so much.
Thank you so much, Sinem. And that allows us to hand over right away to Monica. Monica, I know we're almost at the end of our overall time, but hopefully you can give us a speedy run through your presentation as well. Thank you.
Okay, I'll try. One moment. So can you see my presentation?
Yes, but not in the presenter mode.
And now?
Yeah.
Okay,
yes,
perfect. Hi, and once again, good morning. I'm delighted to present you with the topic regarding brand management and marketing issues. Today, I will present the topic of dark patterns, a hot topic in Europe, including Poland. And let's start with describing dark patterns. So first, there is no specific definition. Dark patterns appear in many legal acts, guidelines, and reports. As a universal definition that is easy to understand is, dark patterns are manipulative tactics used by companies to trick users into taking actions that they might not have taken otherwise. So you can see on the slide manipulative tactics and to trick users. These patterns are often used in online settings such as e-commerce, websites, social media platforms, and mobile apps. If you face the situation listed on the slide, you would have been exposed to dark patterns. Let's say you bought something you didn't intend to. You couldn't unsubscribe from something. You consented to provide personal information, even though you didn't want to. You were unable to find the information you needed to make an informed decision. You pressed a button on a page you didn't intend to press. For example, on pop-ups. There could be many more of these examples. Dark patterns can be associated with trademarks and other intellectual property in various ways. We may be dealing with trademark infringement, for example. We press a button on a website with a logo that infringes a trademark. Also, a graphic on a website to which we are redirected violates copyright. We come across a false advertisement. We think that we are accessing a particular brand's website, which turns out to be a cyber-squatting domain. Dark patterns are regulated in a number of acts, such as Unfair Commercial Practices Directive, General Data Protection Regulation, Digital Services Act, Digital Markets Act. They are not explicitly prohibited in AI Act. However, in chatbots, you can find dark patterns. In general, chatbots are to be designed and developed so that the user knows that he or she cooperates with artificial intelligence. However, sometimes the situation can be opposite. The prohibition of dark patterns is also included in Data Act and the Directive for Financial Services Contracts concluded at the distance. I have to say that the Office of Competition and Consumer Protection in Poland is highly active. And now I will show you some examples. So here the Polish watchdog accused two popular online stores of misleading consumers. The consumers were informed that they could take advantage of a promotional offer and by entering a special code, make a purchase at the lower price. The codes were described along the messages of a special discounts, such as Crazy Wednesday, Birthday Week, and many more. And you can see these keywords on the slide. In addition, on the top of the websites, false timers were presented. This is also an example of dark patterns. Here, the president of the Consumer Authority brought charges against a company operating a popular online resume creation service for failing to provide essential information in a clear and timely manner. Information that the subscription will automatically renew was less visible and written in smaller, lighter text on a gray background. So this is an excellent example of dark patterns. As you can see, the Polish regulator is investigating business activity in the area of dark patterns with increasing frequency. And this may intensify because Polish Watchdog is currently working on a project aimed at combating dark patterns faster and more effectively using artificial intelligence. So there will be a special tool created by our Polish regulator. And coming back to the examples of dark patterns, we find them not only on the websites or apps, but also in gaming, loot boxes, various industry of finance, fintech, tourism, transportation, catering, e-commerce, entertainment, and many others. Here is an example. Want to help your dog by signing up for our newsletter? The answer on the button is yes, gladly. And we can see a smaller font. I don't want to help my dog. It's a classic example of confirm shaming. And confirm shaming is the tendency to use language in user experience design that guilts the reader into the option to decline. Here you can see yes, no buttons. The direction is wrong and the colors are used oppositely. This can confuse the consumer. And here is another example of confirm shaming. Highlighted, you can see highlighted button get discount. And now I hate savings. Denial option. Here is a big never mind button, and instead of simple continue cancellation, cancellation should be as easy as signing up for something, and this graphic doesn't suggest that at all. Finally, I would like to add that different guidelines are being prepared in different countries. There are no such guidelines in Poland yet. They have been created in India, France, and the UK. And in the UK, the preparation of such a guideline was handled by two regulators, one responsible for consumers and the other responsible for personal data issues. So thank you very much. At the very end of the presentation, I would like to add that at Bird and Bird, we are working on topics related to dark patterns. Below, you will also find a QR code to stay in touch with me. And please scan the code and you will be taken directly to my LinkedIn. Thank you very much. And let's keep in touch.
Thank you so much, Monica. And thank you also, Rebecca and Sinem, for the great presentations. I think we had one question, maybe we can answer this one very quickly from Benedict Sherrock Harris. And I think that related back to Rebecca's presentation, but please feel free, any of you, to answer. And the question was, to what extent the concepts presented would be similar to the English concept of passing off. Maybe you can answer that in a sentence or two.
Benedict, if you're still there, could you elaborate your question to what concept should be similar to?
Or maybe Sinem or Monica, do you have any feedback for Benedict on that point? Concept of passing off, how it relates to dark patterns and so forth.
Okay, he elaborated. So he was wondering whether the concept of company name rights and unregistered rights relates to the English concept of passing off. It is, if I understand the concept of passing off rightly, it is related. So insofar as you have to do a similarity test, so you have to ask yourself, if the one company can be confused with the other, or the name, the unregistered rights can be confused with another. I hope this is, so you do have this likelihood of confusion that we all know from the registered trademarks, and you have to test this with the unregistered rights too. I hope this was the right direction you were going.
Great, great. So it seems there is some unfair competition aspect there as well. All right. Thank you again. Thank you so much. And with that, I think we'll head over to our second panel. And for that, let me quickly introduce to you our two speakers for panel 2, which is developments on confidentiality and transparency issues at the UPC and before UK courts. And our two speakers for this panel will be Kat Howell and Jiří Slavik. Kat Howell is an IP solicitor before the English and Welsh courts, and Kat's practice has a strong focus on FRAND, SCP issues, and she has inter alia worked on the central UK Supreme Court cases on White Planet and Conversant versus Huawei, and more recently also on the High Court case of Optus versus Apple. And Kat also has extensive experience in negotiating confidentiality agreements and resolving confidentiality issues. Jiří Slavik is a Czech and European patent attorney, UPC representative, and a current member of the EPI litigation committee for the Czech Republic. And as an in-house patent counsel at Adalvo, his primary work focus is pharma sector, especially generics and value-added medicines. But Jiří also sometimes practices as a solo patent attorney and was also involved in a recent UPC Court of Appeals transparency case. And with that, and without further ado, please, Jiří and Kat, take over.
Thank you very much, Nick, for the kind introduction. I hope you can all hear me and see the slides. Yeah, thanks. So as Nick said, we will cover the topics of transparency and confidentiality, both at the UPC and the UK courts. And in the last part of the presentation, we'll sort of discuss what are the considerations for these two topics together. Before we start, just the mandatory disclaimer that I believe applies to both of us, that everything we say here today are our own personal opinions. Now, before we start going into the UPC decisions themselves, we thought it would be nice to briefly introduce the UPC because we don't know who might be in the audience. And as you may have known, last year, the biggest reform in the European patent litigation system has happened. As of 1st of June 2023, the UPC court has entered into force, which was set up as a court common to the participating EU member states. These are not all the EU member states. Currently, we have 17 contracting member states, and Romania is joining in September as the 18th contracting member states. Also, non-EU countries are not part of the system. So unfortunately, due to Brexit, UK is not part of the system and has withdrawn from the UPC. This new court is supposed to replace the system of traditional national courts for litigation of European patents, for both unitary patents, which were created as a new right with the entry into force of this new system last year, and also traditionally nationally validated European patents granted by the EPO. The UPC is already an exclusive forum for litigating unitary patents and will get this exclusive jurisdiction also for traditional European patents after the transitional period has passed off. And you can see the structure of the court on the slide here. To start off, one of the major debates before the UPC, even before the UPC has started as a new court, and when the rules of procedure were being drafted, were the provisions relating to confidentiality, public access. According to the provisions in the UPC, the public register should be accessible, open to public. The proceedings before the UPC, which considers written, interim, and oral procedure, shall be open to the public. However, nevertheless, there are certain provisions on protection of trade secrets, personal data, and confidential information. When we would categorize the options available under the rules of procedure, we see, thankfully, that decisions and orders shall be published. This should be applicable unconditionally. We have further specific provisions on public access to written pleadings and evidence, which are not available automatically, but have to be requested by a member of the public with a reasoned request. And the judge rapporteur has to decide on such request. And I will go into the details of how such requests work at the UPC later on, and Kat will then compare them with how does this work at the UK courts. There is also a separate provision on requesting confidentiality of certain information by a party to proceedings so that this is not accessible to the public. In that case, the party requesting this has to supply a redacted version of that document that may be provided on such reasoned request to the public. The member of the public in return can lodge an application to access this confidential information, which would be a separate procedure from the initial public request access. Lastly, there are also provisions relating to protection of confidential information by a party to proceedings against the disclosure to the other party. This is something that will be later on covered by Kat. So focusing now on the Rule 2621B and the public access to documents, there is a requirement for a reasoned request. And several of these requests were lodged when the first cases were filed at the UPC initially. We firstly got 2 decisions from the Munich section of the Central Division, which interpret the requirement of a reasoned request quite strictly, and said that a concrete and verifiable reasons are required, and that a wish from a natural person to, for example, form an opinion on validity of a European patent out of personal or professional interest is not a legitimate reason. This was in the first Munich decision. Or that the purpose of education and training is not a legitimate reason to get access to the public documents. This was in the second Munich decision. However, a notable contradictory interpretation later came from the decision of the Nordic-Baltic Regional Division, which decided that there is no need for a specific request, that a credible request and an intention is enough for getting access to the documents. For example, to see how the claim was framed, or that there is, in general, a broader public interest in having access to the documents. And there is also the need to monitor the developments of such a new court and to see how the decisions are made. And basically, it affirmed that there is a principle of open justice under the UPCA agreement. However, because this was contradictory to the earlier 2 Munich decisions, the court suspended the application of this decision and granted leave for appeal. The appeal was indeed filed, and further suspension was given by the Court of Appeal pending the decision on appeal. So finally, with the decision of the Court of Appeal, we have the very much needed clarification of the interpretation what actually a reasoned request is, and how it should be framed in order for a member of a public to get access to court documents. So the Court of Appeal has confirmed that there is a general principle of open justice laid down in the UPCA agreement. However, there is a need for balancing those interests. So you need to balance the interests of a member of a party, and you need to balance the interests that are mentioned in Article 45 of the UPCA agreement. So the interests of the public would be, for example, either the general public interest, so better understanding of the decisions, scrutiny of the court decisions, so that the public has trust in the new court system. There are other legitimate interests, as were mentioned in the other decisions, scientific, educational reasons. These are all valid interests. And perhaps in some cases, direct specific interest of a member of a public might be there as well. And this all has to be weighed with the interests of mentioned in Article 45, which contain not only the protection of confidential information and personal data, also other general interests of justice, mainly the protection of integrity of proceedings, and also whether this request was not made as an abuse, or whether there were any security interests at stake. And because there is this weighing of these interests, the Court of Appeal has distinguished between concluded proceedings and pending proceedings. in concluded proceedings, it said that when you weigh the general interests and the protection of integrity of proceedings, these interests would be usually properly balanced when you give access to the documents to the member of the public because the proceedings had already been concluded. However, in pending proceedings, something more is required in order to outweigh the interest in protection of integrity of proceedings, and that is the specific direct interest of a member of a public which is required, such as, for example, the member of the public being concerned with validity as being a competitor or a licensee, or where he is accused of infringing a patent with a product that is substantially the same or similar as the product being discussed in the UPC infringement case. But when there is this specific direct interest by the member of the public, then the balance would be generally in favor of granting access to the documents. So to summarize, how does it work at the UPC when a public wants to get access to the court documents? Based on the Court of Appeal decision and also on the other decisions which we had from the courts of first instance in other cases. The first thing is that the member of the public must be represented. This was made by an interim order by the Court of Appeal. It was not considered in first instance, but the Court of Appeal said it does not consider it unreasonably burdensome, although one may disagree with that conclusion. The other part is that because you need of this balancing of interests, the requesting party has to specify the purpose and explain why access is necessary in order to allow this balancing. So it's not only assessment of whether the request is abusive or not, but you need to actually put forward the purpose and explain why you need access to the documents. We also know that if you're trying to access documents from different UPC divisions, you need to file separate requests. Again, something which may be considered perhaps burdensome. However, the bar for accessing the documents, especially in concluded proceedings, seems to be rather low. So a general interest of a member of a public should usually prevail. There is no requirement for any direct interest. The court has said that this applies also to proceedings which have come to an end without a final decision, so have been concluded by a settlement. And these count still as concluded proceedings for which a member of the public should be usually given access. The bar is somehow higher in pending proceedings. So as I mentioned before, direct interest is required. This requirement has recently been interpreted by a decision of the Paris section of the Central Division, where the applicant, the member of the public requesting access to the documents at the UPC, was already involved in EPO opposition proceedings against the same patent, but not at the UPC proceedings, and he was granted access to the documents in the UPC invalidity proceedings. The Court of Appeal also said that in such cases, when giving access to documents in pending proceedings, the court may impose some further limitations, for example, impose confidentiality limitation on the party receiving access. This confidentiality requirement was not given in the decision by the Paris section of the Central Division for giving access to the EPO opposition. And it was explicitly mentioned that the documents that were given access to may be used in the parallel EPO opposition procedure. Also, in some of the other decisions, what we see is that the extent of the request is interpreted very literally, in that only access to written pleadings and evidence and not to any other documents is given. For example, there was a request for court-generated documents, which was not allowed because there's no basis for that, apparently. And with that, I'd like to hand over to Kat to take us through how does it work at the UK courts.
Hi, and thank you, Yuri, for that overview of public access in the UPC, and thank you, Nicholas, for the introduction. I'm really pleased to be here today to talk about several topics that I've got a real interest in. So I'm going to start off with a point of technicality, which is how all fun presentations start. We've used the term UK court here, but I am predominantly speaking about the procedure of the process in the English and Welsh courts. With that said, I'll address public access in the UK courts. So starting with the very basics, the British legal system operates with the fundamental principle of open justice in mind. This is well encapsulated in the famous quote from Lord Hewitt on this slide. essentially that justice needs to be seen to be done. This principle is of broad application in the British legal system, and in particular into the access of case documents by the public. With only a few exceptions, all of our courts sit in public, and it's important that justice may be seen to be done by all. In respect of access to documents specifically, the general rule of civil procedure is found in CPR Civil Procedure Rule 5.4c, which formalizes the public non-party access to documents. The rule's copied out on the slide, but essentially it provides that a person who is a non-party or public to the proceedings has an automatic right to gain from the court copies of the statements of case or pleadings, judgments, or orders made in public. And further, but only if the court gives permission, to obtain from the records a copy of any other document filed by the party or communication between the court, party, or another person. This civil procedure rule was recently examined in a Supreme Court decision, Capendring, which I'll discuss on the next slide. The judgment of the Supreme Court in Capendring yet again referred to the principle of open justice when considering public access to documents. The Supreme Court found that the principle of open justice was twofold. First, it's to hold the individual courts and justices to account. And secondly, with particular importance to this topic, it's to enable the public to understand how the justice system works and why decisions are taken. They considered that second point in the context of how court proceedings now take place in the UK. And by that, I mean, historically, civil proceedings were dominated by the spoken word. There was oral evidence, there was oral argument, and you got oral judgment. So if a member of a public turned up to the courtroom, they would hear all of the reasoning involved to understand that judgment. However, these days, as we all know, civil proceedings involve a huge amount of written material. Statements of case, witness statements, documents exhibited, documents disclosed, skeleton arguments, written submissions, leading eventually to a written judgment. It was stated that the way that civil litigation takes place these days, it is difficult for public or the non-parties to follow what's going on in a judgment without access to the written material which underlies them. Therefore, the Supreme Court found that the default position is that the public should be allowed access not only to the parties' submissions and arguments, but also to wider access to all documents placed before the court and referred to in the hearing. That said, and this is similar to, I think, the balancing act that happens in the UPC, the Supreme Court did stress that it doesn't follow that that right is automatic to the wider class of documents. The non-party needs to explain why they seek that access and how granting that access will actually advance the principle of open justice. And the court will carry out a fact-specific proportionality balancing exercise to take account of any other factors, such as the need to protect national security, privacy interests, or commercial confidentiality. Following this decision of the Supreme Court, there was launched a consultation into that Civil Procedure Rule 5.4c that I showed on the previous slide. This consultation, whilst originating from the Supreme Court judgment, also had a broader agenda of addressing transparency issues and the public access to document in the UK. This proposed new civil procedure rule, which came out of the consultation, makes some quite radical changes. It contains two separate provisions which will allow non-parties to obtain further documents as an automatic right, such as witness statements, expert reports, and skeleton arguments. Just by way of reminder, the only present documents that the public can obtain automatically are judgments, orders, and pleadings. Furthermore, this new proposed CPR rule might actually give right to obtaining documents at an interim stage as well as a trial stage. The consultation period for whether this new rule should come into place ended in April, and I believe various submissions from different bodies were considered in a meeting a couple of months ago. As far as I can see, though, there's been no decision yet on whether that broader rule will come into place, and if so, in what form it will come into. In summary, it seems like we have a lot of the same principles as the UPC in the UK, but the application of the recent judgments coming from the UPC show a slightly stricter approach to the type of documents you can access and how automatic that right might be. Whereas the UK, it's much broader and particularly will be if this new civil procedure rule is introduced. What is clear, however, is that one of the factors which both the UPC and UK courts consider before granting access to material is whether that material is confidential. And as we know in IP cases, it's very often the case that documents do contain confidential information. So on that note, I'll turn to examining how a party might introduce confidential material to their case and what restrictions there are on doing that. I'll start with the UPC, which has a very set procedure should a party wish to rely on confidential information. This is set out in Rule 262A, which Yuri briefly mentioned earlier. This rule starts by stating that a party may make an application to the court for an order that certain information contained in its pleadings or the collection or use of evidence in proceedings may be restricted or prohibited, that access to such information or evidence be restricted to certain persons. The rule then sets out various steps which must be taken in making of such an application. It appears there was a little ambiguity in the interpretation of these rules, and that was the subject of a decision in February this year made by the Mannheim Local Division in an action between Panasonic and Oppo. This decision set out a little more detail on the steps to be taken for a party to rely on confidential information, and I've put them on a flow diagram on the slide, but I'll talk through the steps. First, the party needs to upload a document displaying the confidential information to the case management system. They need to mark that as confidential. A separate related proceeding workflow is created on the case management system where the applicant makes this application to maintain confidential status of that document. The court will then review the confidentiality application in this separate related proceedings workflow. Next, if the court intends not to allow the maintenance of confidentiality in full or in part, they will hear from the applicant in advance of their final decision. The court may also issue a preliminary protective order granting the opposing party's representative, but not the actual party themselves, access to unredacted versions of that document solely for the purpose of commenting on the further confidentiality application. If needed, the opposing party's representative may consult with named others before commenting on the document's confidentiality. However, the applicant is given a chance to comment on those to be consulted before that is permitted. The court will then make a final decision on the document's confidentiality. If the confidentiality application is approved, the document remains confidential. If denied, the applicant then has to decide whether to submit that document for use in the action on a non-confidential basis, so essentially waive confidentiality in the document, or keep that document out of the proceedings entirely. For the documents that are considered to be confidential, the terms of the protection are then set. This is a key area of debate and development, in particular, the question of whether a natural person, such as a person employed by the client of an opposing party, should have access to the confidential information of the other party. Such issues have been addressed in a number of decisions recently. For example, the Dusseldorf local decision and Fujifilm and Kodak stated that the idea that there could be an attorney's eyes only confidentiality club, as in with no natural persons within it, would be bound to fail because this procedure is inapplicable at the UPC and counter to the sources of law to be respected by the UPC. However, the Paris local decision has made a decision in the very same month and actually did allow documents to be protected by being shown to external eyes only. It is worth noting that on the facts of that case and the Paris local division, neither party actually sought for a natural person to have access to the documents, which might explain the difference. Overall, it remains to be seen how the UPC local divisions will treat confidentiality protection, and in particular, how narrowly they will allow an applying party to limit access to those documents. And next, I'll move on to the UK. There is not so much a strict or set procedure involved in the pre-trial stages of the action in the UK. Typically, confidential information is introduced to the case by the parties, and it's protected on whatever terms are agreed between the parties or where those terms are in dispute set by the court. If the terms of confidentiality protection of a document end up being disputed by the court, then much like the UPC has recently been grappling with, often a key area of contention is whether an employee or a natural person at the opposing party should have access to the confidential documents. The general precedent is that a natural person at each party should be given access to the confidential material, not least so they can give instructions on the action to their representing lawyers. But there are exceptions to this rule, and they are seen relatively commonly in IP actions. For example, in a recent judgment of Mr. Justice Mellor and Rodeo and Neo, an in-house lawyer was denied access to the confidential information of a competitor. However, although there's a relatively relaxed approach at the pre-trial stages of proceedings to confidentiality, when it comes to the hearing itself or judgments, the court is not so relaxed. And that all-important principle of open justice comes into play. All of the courts aim to have hearings held openly And to hear a court in private session, so excluding the public, the court must be convinced that justice can only be done by closing the court to the public. This does arise, I guess, in an example where a party's case relies on referring to confidential material, and if you can't close the courtroom, they cannot make their case. With regard to public access to confidential documents, as covered earlier in this presentation, the general rule in the UK is that the public should have access to the documents relied upon and referred to in the court so they can understand the judgment being given. But as we mentioned, one of the factors that the courts will consider when maybe denying such a request is whether there's a confidentiality issue at play. And a legal party can protect their confidential documents referred to in court by being accessed by reference to a civil procedure rule 3122. Finally, when it comes to making a judgment, the court makes a huge effort to ensure that no confidential information is referred to in the judgment, so the public can understand what the judgment is about. But where it's necessary to do so, there is often a two-stage hand-down process of the judgment, where a confidential version of a judgment is handed down to the parties. Then the parties make submissions to the court on whether redaction should or could be applied. And then there's often a further hearing where the court determines whether that information should or should not remain confidential in the final version of the judgment. So to wrap up these points on procedure for relying on confidential information, I think one of the key differences between the UK and the UPC is the scrutiny over whether information is not confidential seems to happen at a much earlier stage in the UPC proceedings, thanks to Rule 262A. Whereas in my experience in the UK, there is less regulation over this at the early stages of proceedings, but it comes into play massively when you get to the hearing and the judgment itself, where the court will be much more ready to analyse whether the information should truly be kept confidential with the principles of open justice and transparency in mind. And with that mention of transparency, it's time to hand over to Jiri again to conclude our presentation by discussing the broader principle of transparency and some of the hot issues in that area.
Thank you very much, Kat, for the nice summary of the UK courts and how does the use of confidential information work at the UPC. As we have mentioned, we've put down several hot topics, what should be considered in the broader terms of transparency and confidentiality. For example, for the UPC as opposed to national courts, the UPC will only ever be concerned with European patents. And for those who might not be aware, the EPO maintains an EP register that is completely accessible to the public, save for very exceptional submissions of the parties. And hence, in my view, the UPC should sort of follow this approach and be as much as open as possible, because only European patents are being litigated before the UPC court. This follows the other point that the interpretation of the claims plays a crucial role both during validity and enforcement proceedings of patent rights, especially in view of legal certainty of third parties. And in that sense, we should avoid the so-called anchoracats and secure that the same interpretation of the claims applies during both situations, and that in both instances, the right holders need to be held accountable to the interpretation they adopt in these two different kinds of proceedings. This is further contrasted with the fact that we're dealing with different rights. So the nature of patent rights as proprietary rights, they are capable of affecting everyone and everybody. And decisions about these rights require a high level of public scrutiny, again, during both examination and grant proceedings, as well as during enforcement proceedings. This could have been easier for the UPC to deal with because, as opposed to other general, national, civil and family courts in the member states, the UPC deals only with patent rights. And so there is no requirement as in these other courts dealing with family issues with more sensitive information at stake to a much higher degree. In fact, any conduct that by the right holder or the applicant or the patentee enforcing their patents aimed at sort of concealing the relevant prior art may potentially be detrimental both to the third parties and also to the rights holders themselves. Enforcement of invalid patent rights or IP rights or making misleading statements at IP offices may trigger potential anti-competitive investigations. And we had cases going to this extent and investigating how the parties behaved. Kat, do you want to chip in on the competition law more?
Yeah. On the mention of competition law and kind of related to FRAND licensing, in the licensing and standard essential patent sphere, there's also a consideration of competition law and FRAND. And these FRAND rates are intended to be fair, reasonable, and non-discriminatory. So it's seen there's an inherent interest in making these rates public, so the transparency could allow the market to assess the true non-discriminatory nature of the licenses. However, in a market where licensing under those terms is obligatory, there's a real tension with the interest of parties to keep this commercial confidential information away from the public. And there's further competition law concerns which weigh both in favour and against more transparency. On one hand, publication of parties' confidential information could be anti-competitive because it weakens their position in the market, or if sharing of just certain rates might actually be seen to be cartel-like. On the other hand, it would be clearer when confidential anti-competitive behaviour was at play if such information was published. But again, parties obviously have a right to keep that commercially sensitive material confidential.
Thank you, Kath. We do note that the access to core documents is very different on a country-by-country level. We have already seen today the difference between the UPC and the UK approach. Other national legal systems are also very different. For example, in my home country, Czech Republic, the access is very limited. So there are differences, but also the option of accessing public court hearings is very different. I know, and Kat can confirm that the UK is very much proactive in the sense that they are streaming court hearings on YouTube, for example. The Court of Justice of the European Union was also active in streaming some of the major Grand Chamber hearings recently. Again, this is opposed with the UPC being more reluctant in the way they would be able to provide video links or streaming of court hearings for non-parties and non-representatives. We know, based on the rules of procedure, that video conference or hearings are possible, but they are streamed to a courtroom. So the public would have to watch it from the courtroom, even though the whole proceedings are held online, which for me, this does not really make sense in the 21st century. On the other hand, we're talking here about having public access and how is this required. There is also a general principle that you need to protect confidential information and sensitive business information or even financial data, because then you could have litigation which aims at fishing for this information and abusive litigation trying to, for the sole reason of obtaining said confidential information, which goes hand in hand with trade secrets. Kat, do you want to provide some further insights on trade secrets?
No, just to say that it's often seen that they have a bit of a sort of enhanced protection and compared to, say, your standard commercial confidential information.
Thank you. So that concludes the summary of our presentation. And Nick, we're happy to take any questions.
Thank you so much, Kat and Yuri, for your wonderful presentation. I haven't seen any question in the chat as of now. If there are any, please do feel free to ask them now. I think there is one particular aspect that I'm personally interested in that pertains especially in form of a question back to Kat, I presume, because at the end of slide 12, which you elaborated on, you've shown us that parties engage with the court in the UK proceedings, especially the end of the proceedings, and then the court will seek to minimize redactions, for example, in a decision. The big question that came to my mind in that regard is the court even the right forum to promote such transparency or transparency in general? What's your point of view on that?
Yeah, this is something that's arisen in lots of cases recently, actually. One key example is Justice Mellor's form of order judgment in InterDigital and Lenovo last year. He expressed a view that no doubt that the licensing or SEP licensing market would actually operate much more smoothly if there was transparency over the terms of the licenses in the market, and perhaps there would be much less litigation on it as well. But he didn't take the step of making such confidential terms public in his judgment. Justice Burse, now Lord Justice Burse, also gave a decision on confidentiality in OnMyPlanet and Huawei and expressed a similar view that transparency would be optimal, but he reached the conclusion that it wasn't something to be achieved by lifting redactions in a judgment. And in my view, I do think the role of the court, at least in the UK, is to consider what is required for people to understand the reasoning and how the conclusions were reached on the evidence that was in front of them. But their role is not some form of market study or policy consideration concerned with transparency. And that sort of thing might be better addressed by a relevant industry body to ensure that decisions on that kind of matter are addressed across an entire industry sphere.
Lovely. Thank you so much. Yeah, unfortunately, we're running out of time, but there are also no other questions on the chat as well. And with that, again, thank you both for your wonderful presentation, and also to the panelists of panel 1, of course. Had a little bit more time pressure. And with that, happy to hand over for some concluding remarks to Samantha and Debbie.
Thank you very much, Nicholas. Thank you so much to all our panel speakers for really, really great sessions today for both of the panels. And thank you so much for joining us today. And shortly after the announcements, we want to invite all of you to turn on your cameras so that we can take a summit photo of this European satellite session. So please stay behind a little bit after the announcement. So first, I want to remind all of you that we will be sending you a feedback form after the session. So we really hope that you can provide us with your valuable feedback to tell us your preference, what we did well and what we can do better so we can plan for the future AIPPI Young Members events. So next up, we will be having our Americas session, satellite session at 6 p.m. CEST. So there will be very interesting regional topics on cultural elements and alike. So really encourage you all, if you have time, to join that as well. For the AIPPI Congress this year, it will happen in October in Hangzhou. And the early bird registration, as Simone has mentioned, will end on 9th of July. So just want to remind all of you to take this advantage and register while available. And we look forward to seeing you then. And also look out for the Young Members events, because we will be hosting the Young AIPPI Members Forum and other gathering events there as well. Lastly, also we want to remind all of you about our AIPPI Young Members WhatsApp group. So I'll be sending it to the chat. And if you still haven't joined us yet, do feel free to click the link and join our WhatsApp group so you will receive the latest updates. So now we will be doing the group photo. Events team, please feel free to let us know when you're ready, and we will do the photo.
We're ready.
Thank you so much. 1, 2, 3, smile and cheese.
Thank you.
Thank you so much. So thank you once again. And on behalf of the AIPPI Members Advisory Committee, we would like to extend our utmost gratitude to all of you attending, to our esteemed speakers, our host, Nicholas, and the AIPPI Bureau, General Secretariat, the events team for your amazing support to us. We'll see you at the last session. If not, we'll see you in person in the Congress and other events, of course. See you all. Thank you very much for joining us again.